Behind closed doors at Clarence House and Buckingham Palace, sensational media reports and viral internet commentary have ignited a fiery debate surrounding royal titles, dynastic succession, and internal household dynamics. The dramatic premise that Queen Camilla erupted in anger over Prince George receiving elevated royal status while her own grandchildren were supposedly left out reflect a recurring tension in modern public fascination with the British royal family. While sensationalized narratives framed the situation as an explosive personal feud between the Queen Consort and the royal establishment, the reality is rooted in rigid constitutional law, centuries-old letters patent, and the fundamental distinctions governing the line of succession. The core of the dramatic narrative centers on the stark contrast in official status between Prince George of Wales and Queen Camilla's grandchildren from her first marriage to Andrew Parker Bowles. Prince George, born as the eldest son of Prince William and Catherine, Princess of Wales, occupies a unique and historic position as second in line to the British throne. From birth, Prince George automatically inherited the formal style of His Royal Highness and the title of Prince under the 1917 letters patent issued by King George V, which explicitly grant royal titles to the children and grandchildren of the sovereign in the male line. As the future king, Prince George's titles and constitutional designations are enshrined in United Kingdom statutory law and common law precedent. Conversely, Queen Camilla's biological grandchildren, Lola and Freddy Parker Bowles, as well as Eliza, Gus, and Louis Lopez, are the children of Tom Parker Bowles and Laura Lopez. While they are cherished family members within the King and Queen's blended household, they carry no royal bloodline and fall entirely outside the line of succession to the British crown. Consequently, under British constitutional law, there is no legal framework or precedent that allows non-royal step-grandchildren of a sovereign or queen consort to receive royal peerages, prince or princess titles, or styles of royal highness. Despite the strict legal boundaries, clickbait media channels and online commentators frequently seize upon visible public events to construct dramatic storylines of palace favoritism and personal resentment. The historic 2023 coronation of King Charles III and Queen Camilla served as a prime example of how symbolic roles are interpreted by the public. During the ceremony at Westminster Abbey, both Prince George and Queen Camilla's grandsons, Gus Lopez, Louis Lopez, and Freddy Parker Bowles, served as official pages of honor. They wore matching ceremonial red coats, carried the royal robes through the nave, and appeared together on the balcony of Buckingham Palace before a global audience of hundreds of millions. For constitutional historians, the inclusion of Camilla's grandsons as pages of honor was viewed as a remarkably modern and inclusive gesture by King Charles III, publicly embracing his blended family on the world stage. However, online tabloids quickly flipped the narrative once the coronation concluded, focusing instead on the fact that Prince George continues to move forward with official royal duties, formal titles, and specialized constitutional training, while Camilla's grandchildren return to their private daily lives as normal schoolboys. Sensational claims alleging that Queen Camilla went on an outrage-filled rampage demanding titles for her grandchildren completely ignore both her public stance and the constitutional realities of the monarchy. Throughout her decades alongside King Charles, Camilla has consistently emphasized the importance of keeping her own children and grandchildren out of the intense spotlight of royal media scrutiny. Her son, Tom Parker Bowles, has repeatedly stated in public interviews that he and his sister are not part of the royal family in an official sense, noting that their mother married into the institution, but they themselves remain private British citizens. From a governance perspective, King Charles III and Prince William have both championed a slimmed-down working monarchy designed to reduce taxpayer burdens and maintain public trust. Granting arbitrary titles or state-funded roles to non-royal relatives would directly contradict this long-term strategy, triggering severe public pushback and parliamentary criticism. King Charles III remains firmly committed to preserving established constitutional rules, ensuring that formal titles remain strictly tied to official duties and the direct line of succession. In conclusion, while viral internet headlines paint a picture of dramatic palace arguments and bitter family divisions, the distinction between Prince George and Queen Camilla's grandchildren is entirely a matter of constitutional law rather than personal favoritism. Prince George's royal title reflects his future destiny as sovereign, while Queen Camilla's grandchildren enjoy the freedom and privacy of ordinary life outside the royal spotlight. The House of Windsor continues to balance its duties as an ancient state institution with the modern realities of a blended family, upholding centuries of royal tradition with clarity and firmness. The constitutional framework governing the distribution of titles, peerages, and dynastic honours within the British monarchy is anchored in century-old statutory provisions, letters patent, and established common law principles. The ongoing administrative alignment across the royal estate has reinforced a strict boundary between public state duties and private household relations. This separation ensures that formal recognition remains strictly reserved for individuals positioned within the direct, legal line of succession to the crown. Under the 1917 letters patent issued by King George V, subsequently updated by Queen Elizabeth II in 2012 prior to Prince George's birth, the title of prince and the style of royal highness are explicitly restricted to the children of the sovereign, the grandchildren of the sovereign in the direct male line, and the eldest living son of the eldest son of the Prince of Wales. As the eldest child of Prince William, Prince George automatically holds his title as a matter of constitutional law. His position as second in line to the throne mandates formal state recognition, specialized preparation, and integration into official duties under statutory governance. In contrast, non-royal step-family members, including Queen Camilla's biological grandchildren through her children Tom Parker Bowles and Laura Lopez, exist entirely outside the line of succession. British law provides no constitutional mechanism or legal precedent for extending peerages or royal styles to step-grandchildren who do not share royal bloodlines. While members of blended royal households participate in historic ceremonial roles, such as serving as pages of honor during the 2023 coronation, these non-hereditary ceremonial roles carry no permanent administrative status or formal title. The management of sovereign affairs under King Charles III and Prince William continues to prioritize a streamlined, highly accountable working monarchy. This operational model prevents the creation of arbitrary titles or new state-funded roles for non-working relatives, safeguarding the institution's public integrity and fiscal alignment. By strictly enforcing long-standing constitutional boundaries, the House of Windsor maintains a clear distinction between the hereditary obligations of the direct royal line and the private, UN-titled lives of non-royal family members. The legal and constitutional framework governing title bestowal, succession dynamics, and royal household governance remains anchored in established statutory precedent and letters patent. The ongoing operational alignment across the British monarchical system enforces a fundamental separation between public state titles and private family relationships, ensuring that formal dynastic honors remain strictly reserved for individuals positioned within the direct, constitutional line of succession to the crown. The distribution of styles, titles, and peerages within the United Kingdom operates strictly under sovereign prerogative guided by constitutional statutes. The primary instrument dictating princely styles is the 1917 letters patent issued by King George V, subsequently amended by Queen Elizabeth II in 2012 prior to Prince George's birth. Under this historic directive, the title of prince or princess and the style of his or her royal highness are restricted to the children of a sovereign, the male-line grandchildren of a sovereign, and the eldest living son of the eldest son of the Prince of Wales. Because Prince George is the eldest child of Prince William, his princely status and style of royal highness are automatic rights established by letters patent and constitutional law. His legal standing as second in line to the British throne requires comprehensive state preparation, security integration, and administrative alignment to fulfill future constitutional obligations. In contrast, step-relatives resulting from modern blended marriages carry no dynastic bloodline status. Queen Camilla's biological children, Tom Parker Bowles and Laura Lopez, and her 5 biological grandchildren remain private British citizens. The British legal system provides no constitutional mechanism, statutory authority, or historical precedent for granting royal titles, styles of royal highness, or state-funded peerages to step-grandchildren of a sovereign or queen consort. Public commentary surrounding the inclusion of Queen Camilla's grandsons as pages of honor during the 2023 coronation highlighted ceremonial inclusion rather than constitutional title bestowal. Pages of honor perform historic ceremonial duties, such as carrying the sovereign's and queen's robes for the duration of a coronation ceremony. These appointments carry no permanent royal titles, official rank, or ongoing administrative duties. The policy enforced by King Charles III and Prince William emphasizes a streamlined, fiscal-conscious working monarchy. Arbitrarily creating honors or administrative roles for non-working relatives or non-royal step-family members would directly breach modern public sector ethics guidelines and provoke significant parliamentary scrutiny. By upholding clear statutory lines, the sovereign household maintains absolute transparency, ensuring that state titles remain strictly connected to public service, accountability, and the direct line of succession. The statutory guidelines governing the administration of royal titles and succession rights derive directly from parliamentary legislation enacted over 3 centuries of constitutional development. Primary among these acts are the Bill of Rights 1689 and the Act of Settlement 1701, which established the eligibility for the crown, and by extension, the formal titles associated with royal lineage, is fundamentally subject to statutory regulation rather than discretionary royal preference. This legal foundation means that no monarchical member of the royal household possesses the legal authority to grant princely status or peerages outside the strict parameters set by law and historic letters patent. Within the statutory framework, the distinction between working members of the royal family and private citizens associated with the royal household remains absolute. While the sovereign retains limited authority under royal prerogative to issue letters patent regarding styles and titles for direct bloodline descendants, this power cannot be applied to step relations or individuals outside the established line of succession. Stepchildren and step-grandchildren of a reigning monarch or queen consort hold no formal position within the royal hierarchy, receive no public funding from the sovereign grant, and carry no statutory entitlement to state protection or formal peerages. The operational separation between official state representation and private family relationships has been further reinforced through modern public audit frameworks. The Sovereign Grant Act 2011, which governs a financial allocation provided by Parliament to support the monarch's official duties, explicitly prohibits the distribution of public funds to non-working family members or non-title relatives. Consequently, the administrative structures of Clarence House, Buckingham Palace, and Kensington Palace operate under rigid compliance oversight to ensure that all household expenditures, diplomatic engagements, and security allocations are strictly tied to statutory duties and recognize constitutional roles. This systematic adherence to constitutional law maintains a distinction between public duty and private family ties. By anchoring the distribution of styles, titles, and public support strictly within statutory law and direct lineage, the monarchy ensures that its formal institutions remain transparent, legally bounded, and fully aligned with modern democratic standards of public governance. The administrative and constitutional structures of the modern British monarchy operate within an intricate system of statutory law, parliamentary oversight, common law precedents, and centuries of administrative tradition. To understand the ongoing governance of the royal estate and the strict rules that dictate titles, styles, and formal state roles, it is necessary to examine the foundational mechanisms that regulate every aspect of the sovereign household. Far from being a matter of personal whim or informal family preference, every title granted, every public expenditure authorized, and every formal duty performed by a member of the royal family is governed by a complex legal and regulatory framework designed to ensure transparency, constitutional propriety, and democratic accountability. At the heart of this system lies a distinction between the sovereign in their official capacity as head of state and the sovereign as a private individual. This dual nature of the crown shapes how the royal estate is organized, managed, and audited. The official functions of the monarch are funded through the Sovereign Grant, a consolidated public funding mechanism established under the Sovereign Grant Act 2011. This grant, which replaced the historic civil list and individual grants and aid, is calculated as a percentage of the net revenues generated by the Crown Estate, a vast portfolio of land and property owned by the sovereign in right of the Crown, but managed by an independent statutory body. The revenues from the Crown Estate flow directly into the public treasury, from which Parliament allocates a specified portion to support the official duties of the King and the working members of the royal family who assist him. Crucially, the Sovereign Grant Act imposes strict compliance standards and statutory prohibitions regarding how these public funds may be deployed. Public funds are strictly reserved for official engagements, state entertainments, the maintenance of occupied royal palaces, administrative staffing, and official international travel. The legislation explicitly forbids the allocation of sovereign grant funds to support non-working relatives, private step-family members, or personal pursuits unrelated to state representation. Every pound spent from the sovereign grant is audited by the National Audit Office and reviewed by the House of Commons Public Accounts Committee. This continuous parliamentary scrutiny guarantees that no public money is diverted toward private family members, regardless of their proximity to the king or queen consort. The management of royal titles and honorific styles follows an equally rigid constitutional logic. The distribution of titles such as prince, princess, and royal highness is not controlled by personal affection or modern social conventions, but by the legal doctrine of sovereign prerogative exercised through explicit letters patent. Letters patent are public legal instruments issued under the Great Seal of the realm, carrying the full weight of statutory authority within the domain of royal honors. The fundamental blueprint for princely status in the modern era remains the 1917 letters patent issued by King George V during the First World War. When George V issued these letters patent, his goal was twofold: to streamline the royal house by reducing the number of individuals holding princely status, and to establish clear, unambiguous rules for future generations. The 1917 directive established that the style of royal highness and the title of prince or princess were strictly limited to three distinct categories: the biological children of any sovereign, the male-line grandchildren of any sovereign, and the eldest living son of the eldest son of the Prince of Wales. All other descendants in deeper generational lines were directed to use the courtesy titles or surnames of non-royal peers. In 2012, Queen Elizabeth II issued new letters patent amending this framework prior to the birth of Prince George of Wales. Recognizing that the Succession to the Crown Act 2013 was replacing the centuries-old rule of male preference primogeniture with absolute primogeniture, where the eldest child inherits the throne regardless of gender, the Queen extended princely status and the style of royal highness to all children of the eldest son of the Prince of Wales, rather than just the eldest son. This ensured that if Prince William and Catherine's firstborn child had been female, she would have automatically held the title of princess from birth and remained in line to succeed to the throne ahead of any younger brothers. These legal instruments demonstrate why Prince George, Princess Charlotte, and Prince Louis automatically hold their titles as a matter of statutory right and constitutional necessity. Prince George's position as second in line to the throne is a matter of state importance. His title reflects not a personal gift from his family, but his future constitutional role as head of state, Supreme Governor of the Church of England, Commander-in-Chief of the Armed Forces, and head of the Commonwealth. His preparation for these future duties involves long-term institutional planning, security integration directed by the Home Office of Metropolitan Police, and educational pathways designed to equip him for sovereign governance. Conversely, individuals who enter the royal sphere through modern blended family structures operate under entirely different legal parameters. Queen Camilla's children from her marriage to Andrew Parker Bowles, Tom Parker Bowles and Laura Lopez, as well as her 5 biological grandchildren, are private British citizens. Because they possess no biological lineage connecting them to the hereditary succession of the crown, there is no statutory authority, letters patent, or constitutional mechanism that could grant them royal titles or place them within the line of succession. In British constitutional law, a queen consort is the spouse of the reigning king, holding her rank and style through a marriage rather than through independent hereditary right. While the queen consort plays a vital role in supporting the sovereign in his official duties, her position does not confer dynastic status upon her pre-existing biological family. Her children and grandchildren retain their private citizen status, remaining outside the scope of public funding, official state duties, and royal honors. This legal boundary is recognized and respected by all parties involved, ensuring that private family life remains protected from the intense public oversight and constitutional obligations that bind working royals. The inclusion of non-royal family members in major ceremonial occasions, such as the 2023 coronation, where Queen Camilla's grandson served as pages of honor alongside Prince George, represents a traditional, temporary ceremonial appointment rather than a change in constitutional status. Pages of honor are historical positions created for specific state ceremonies, such as coronations or the state opening of Parliament. Individuals appointed as pages carry out localized duties, such as supporting the heavy ceremonial robes of the king or queen as they process through Westminster Abbey or the Palace of Westminster. Once the ceremony concludes, the appointment ends, carrying no permanent peerage, royal style, or ongoing administrative role within the sovereign household. Beyond the legal rules governing titles, the modern operational culture of the British monarchy has undergone a profound transformation toward professionalization, compliance, and strategic alignment. Under the direction of King Charles III and the Prince of Wales, the management of royal estates and administrative offices has been reorganized around principles of efficiency, sustainability, and strict institutional integrity. The operational divisions of Buckingham Palace, Clarence House, and Kensington Palace now function through unified administrative workflows that coordinate travel manifests, conflict of interest assessments, and official engagement schedules in real time. This modernization process extends directly into the management of royal private estates, such as the Duchy of Lancaster and the Duchy of Cornwall. The Duchy of Lancaster, a private portfolio of land, property, and assets held in trust for the reigning sovereign, provides a king with independent private income known as the privy purse. The Duchy of Cornwall, a similar landed estate created in 1337, provides a private income for the heir to the throne, Prince William. Both duchies operate under rigorous modern financial management, paying voluntary income tax on their net surpluses and publishing comprehensive yearly financial reports that detail land stewardship, environmental sustainability goals, and financial performance. The clear separation between official state functions funded by the sovereign grant, private estate revenues generated by the duchies, and the completely independent private lives of non-royal relatives forms a cornerstone of modern monarchical stability. By strictly adhering to statutory boundaries and letters patent, the House of Windsor ensures that the distribution of honors, titles, and public resources remains totally free from personal discretion or administrative ambiguity. This unwavering commitment to constitutional law guarantees that the monarchy functions as a transparent, honorable, and enduring institution capable of fulfilling its constitutional duties to the United Kingdom and the broader Commonwealth. The constitutional principles regulating the distribution of royal styles, peerages, and dynastic titles within the United Kingdom operate entirely independently of personal family dynamics or private household preferences. The legal structures governing the British monarchy establish a permanent divide between public state representation, which is governed by statutory law and hereditary succession, and private step-family relationships within modern blended households. The legal authority to grant, alter, or restrict princely styles and the honorific title of Royal Highness resides exclusively with the reigning sovereign, exercised through legal instruments known as letters patent. Under the foundational 1917 letters patent issued by King George V, as amended by Queen Elizabeth II in 2012, princely titles are strictly limited to direct bloodline descendants in the male line. Because Prince George of Wales is the eldest son of the heir apparent, his formal style is His Royal Highness, and his princely status are automatic constitutional entitlements tied directly to his position as second in line to the throne. His position mandates formal integration into state ceremonies, ongoing constitutional preparation, and official inclusion in the sovereign structure. Conversely, step-grandchildren born into non-royal bloodlines, such as Queen Camilla's biological grandchildren through her children Tom Parker Bowles and Laura Lopez, exist entirely outside the hereditary line of succession. British constitutional law provides no statutory framework, legal precedent, or royal prerogative by which non-royal step-family members can be granted titles, peerages, or state-funded roles. While step-grandchildren may participate in temporary, non-hereditary ceremonial roles during major state events, such as serving as pages of honor during a coronation, these appointments carry no permanent royal rank, official style, or ongoing administrative status. The modern operational framework of the monarchy, directed by King Charles III and the Prince of Wales, reinforces a streamlined working structure centered on public accountability and statutory compliance. Public funds administered through the sovereign grant are strictly allocated to working members of the royal family fulfilling official state duties. By maintaining rigid adherence to statutory law and established letters patent, the House of Windsor ensures that state honors remain strictly connected to constitutional duty and direct lineage, completely separate from private family structures. The long-term governance of the sovereign household rests upon statutory frameworks that regulate every financial, administrative, and constitutional function within the royal estate. The operational balance maintained between the reigning sovereign, the heir apparent, and working members of the royal family operate strictly under parliamentary mandates, leaving no room for discretionary departures or informal structural reorganizations. The management of sovereign property, including historic palaces, state archives, and royal collections, is governed by statutory trusts and parliamentary acts. Properties such as Buckingham Palace, Windsor Castle, and the Palace of Holyrood are held by the sovereign in right of the crown for future generations, rather than as personal assets. Consequently, access, usage, and administrative oversight of these official residences fall under the direct supervision of the Royal Household Department, regulated by audited public accounts. In financial matters, the Sovereign Grant Act 2011 serves as a primary statutory mechanism establishing accountability. The National Audit Office continuously reviews household expenditures to ensure that public funding remains strictly restricted to official state engagements, diplomatic hospitality, property maintenance, and official travel. Non-working relatives, private step-family members, and personal acquaintances carry no entitlement to state funding, public security allocations, or official palace accommodations. The distinction between public state duty and private life extends directly to the awarding of state honors, decorations, and official patronages. Honors such as the Order of the Garter, the Order of the Thistle, and the Royal Victorian Order are conferred strictly through official channels under established rules. Appointments to official patronages of charities, civic organizations, and military regiments undergo rigorous vetting by administrative committees to ensure complete alignment with public interest standard guidelines. By maintaining strict compliance with statutory legislation, constitutional precedents, and letters patent, the administrative offices of the monarchy preserve institutional stability. The House of Windsor remains bound by the rule of law, ensuring that all state roles, formal titles, and public resources remain strictly connected to hereditary constitutional service and transparent governance. The constitutional framework governing royal titles, succession rights, and household administration within the British monarchy is anchored in statutory legislation, established letters patent, and centuries of administrative tradition. The ongoing management of the sovereign household enforces a clear separation between public state obligations, which are governed by statutory law and hereditary succession, and private step-family relationships within modern blended households. The legal authority to grant, alter, or restrict princely styles and the honorific style of Royal Highness resides exclusively with the reigning sovereign, exercised through legal instruments known as letters patent. Under the foundational 1917 letters patent issued by King George V, as amended by Queen Elizabeth II in 2012, princely titles are strictly limited to direct bloodline descendants in the male line. Because Prince George of Wales is the eldest child of the heir apparent, his formal style as His Royal Highness and his princely status are automatic constitutional entitlements tied directly to his position as second in line to the throne. His standing mandates formal integration into state ceremonies, ongoing constitutional preparation, and official inclusion in the sovereign structure. Conversely, step-grandchildren born into non-royal bloodlines, such as Queen Camilla's biological grandchildren through her children Tom Parker Bowles and Laura Lopez, exist entirely outside the hereditary line of succession. British constitutional law provides no statutory framework, legal precedent, or royal prerogative by which non-royal step-family members can be granted titles, peerages, or state-funded roles. While step-grandchildren may participate in temporary, non-hereditary ceremonial roles during major state events, such as serving as pages of honor during a coronation, these appointments carry no permanent royal rank, official style, or ongoing administrative status. Dramatic media claims alleging that members of the royal family can unilaterally strip or modify the official titles of a queen consort contradict constitutional law. Under statutory precedent and royal prerogative, the authority to regulate peerages and titles rests solely with the reigning sovereign, subject to parliamentary legislation. No Prince of Wales, household official, or administrative body possesses the legal authority to alter the constitutional standing of the Queen Consort, whose position is recognized under statutory frameworks governing the monarchy. Financial governance across royal households is similarly regulated by explicit statutory frameworks. The Sovereign Grant Act 2011 governs the public funds allocated by Parliament to support the sovereign's official duties. Public allocations are strictly audited by the National Audit Office and reviewed by the House of Commons Public Accounts Committee. State funds are legally restricted to official state engagements, diplomatic functions, the maintenance of occupied royal palaces, and official travel, prohibiting the distribution of public resources to non-working relatives or non-titled family members. Sensationalized media coverage often contrasts with the genuine, light-hearted nature of public statements made by individuals close to the royal household. In contrast to exaggerated online narratives, authentic interviews, such as those featuring Queen Camilla's sister, Annabel Elliot, reflect close family ties, mutual respect, and a clear understanding of the boundaries separating personal family life from official state duties. The operational framework directed by King Charles III and the Prince of Wales reinforces a streamlined working structure centered on public accountability and statutory compliance. By maintaining rigid adherence to statutory law and established letters patent, the House of Windsor ensures that state honors remain strictly connected to constitutional duty and direct lineage, completely separate from private family structures.